okay, we can talk and have a discussion about what solidarity means, but when it comes to rights of people, these are obligations, and it is a responsibility for states to comply with those rights. It's not a question of solidarity, as we can understand it differently. When you look, especially when you talk about refugees, there are very clear standards, legal standards, which lay down obligations to the states. And now there seems to be, with this crisis thing, an attempt to, oh, we need new paradigms, new rules. Well, the rules are very clear, you know? Rules are very clear, and if what this new paradigm rationally means is lowering down those standards for returns and readmission to be more effective, this is problematic from a many number of perspectives. When it comes to Turkey in particular, much discussion has been taken as to whether Turkey is a safe third country. And it is here where the readmission agreement becomes more critical. When you put together an EU readmission agreement with the labeling of a country as a safe third country, this becomes very poisonous. It becomes very poisonous because what is this safe third country idea? Well, according to UNHCR, it is a country where asylum seekers may be returned where they have, where they will be secured, where they could seek asylum in a proper, fair, and effective way. Is Turkey really such a place? Well, I don't think so. Turkey and many international organizations have very clearly stipulated Turkey is not a safe third country. What are we playing with? Turkey has ratified the 1951 Convention, but has a geographical limitation exempting it from accepting refugees from non-European countries. So it's as simple as that. It's as simple as Turkey cannot be a safe third country. We can politically argue, and you can politically uphold, oh yes, this is safe because we have this and that, but letter of the law is not. And unfortunately, most of these agreements and these practices of sending people back, as you know, these are not irregular migrants. Let's be clear. I mean, Eurostat has very clearly stipulated, when you look at the statistics, that most of the nationalities that have entered through Turkey to Greece were mainly, I insist on that, coming from countries of refugees. Not only Syrians, you have Afghanis, you have Iraqis. Those people cannot be framed as irregular migrants. They have a right to asylum, and as such, they have a right for their asylum application to be individually considered and treated. The problem with this readmission agreement is that people can be sent back, and this undermines this individual case consideration and assessment of the asylum seekers in Greece. The fact that the EU-Turkey readmission agreement doesn't talk at all about its relationship with the safe third country principle proves that the agreement itself, doesn't provide enough guarantees. And in my view, does not pass the human rights test. There is not a meaningful way to ensure that those people who are sent back to Turkey actually their rights will be guaranteed. There is no post-readmission monitoring system at all. Even if European institutions tell us, oh yes, all is good there, no one believes that, really, frankly. How can the European Commission tell us that, thank you, I will finish in a minute, tell us that Turkey complies with basic rule of law and fundamental rights? I mean, this is really a joke, sorry. This is really, we cannot trust Turkey on this. No state can be trusted on this. No state should be trusted on, rights of people. That is why we have, democratic rule of law, checks and balances there. And this is precisely what is lacking in Turkey. And it seems to be lacking also in Brussels sometimes. Now, just to finish my presentation, at the moment there are a number of pending cases have reached the Luxembourg court of people, of three people, 2 Pakistani nationals and 1 Afghani, who are challenging the legality of the EU-Turkey statement, I think for the very good reasons. And they have brought a direct action for annulment, saying that the agreement adversely affects their rights, and especially violates the principle of non-refoulement and also chain refoulement. And these cases are pending at the moment. It is to be seen if the court will admit, will give admissibility to considering those cases. I really hope the court will do that because of the importance of the matter. These cases raise a number of concerns that you have there, not least the point that Turkey is not a safe country and that they will be returned to a country where there's no way to guarantee at all their protection. But also because I'm sure you saw also in the media, we talk about a statement, EU-Turkey statement. And the word statement was very carefully chosen not to talk about an agreement. Precisely to avoid this rule of law that I'm talking about, that the European Parliament had a say on this deal with Turkey, that I would say dirty deal with Turkey, and that the court could exercise judicial review on the statement. And they say, oh, it's a statement, it's a political declaration. Yes, fine, but a political declaration that has very clear impact on people. So you can call it legally whatever you want, but the statement has very clear legal effects on people, which adversely affect their rights. So I'm not a judge in Luxembourg, unfortunately, to admit the case, but I really hope the court will go for it and at least will say that the statement is illegal and that the European Union, the Council, should have adopted an agreement. Because at the end of the day, we are talking about the legitimacy. It is really a question of legitimacy of the EU. What phase can the EU go to Turkey to tell them to respect rule of law and human rights, to accede the Union, when the European Union itself doesn't do that? Thank you very much. I will leave it here.